Welcome to Industry Viewpoints, a video series brought to you by American Bankruptcy Institute. In our programs, we feature experts providing views on the current state of affairs in industries or on key issues with a focus on what may lie ahead. Filmed here at ABI's Winter Leadership Conference, my guest on this special edition of Industry Viewpoints is Derek Abbott from Morris Nichols in Delaware. Derek was the moderator for a key panel here on the opening day of our conference in Los Angeles, looking at mass tort Chapter 11 cases. Well, you know, these gigantic tort cases are really very new. I mean, I guess the first really big ones were the tobacco cases.
Johns Manville,
Manville, yeah.
A.H. Robbins, Dalcon Shield, and asbestos were the early cases.
Well, and now we've moved into different kinds of torts entirely. And I wonder, Derek, some folks have thought that the bankruptcy system is a better system for dealing with these mass torts than the tort system. Do you have any sense about that?
Well, it's interesting. You know, every case is different, Bill, but you know, one of the things that the bankruptcy system was designed to do way back when was to take a debtor's problems and find one centralized forum to deal with resolving creditor issues. And particularly in some of these larger cases where you would have tort system litigation spread across the country, you know, bankruptcy provides an opportunity to get all the parties in one place, represented by committees, and try to deal with these massive problems efficiently. And if you look probably at any one of these cases, it doesn't seem like the most efficient process. But when compared to a sort of a piecemeal approach in the tort system, they're probably much more efficient. And
well, you know, come to think of it, you could have a multi-district panel dealing with pretrial issues in torts, but that's only good for federal courts. It's not going to bring in state courts.
Correct.
And one would have thought that if class actions in state or federal courts could have dealt with a problem, that's where it would be dealt with, is in class actions. But it's not. I mean, it seems to me we're left with bankruptcy as the best alternative for a system that really is not designed to deal with these kinds of problems.
I think that's right. And you know, certainly the plaintiff's bar is highly sophisticated and has got a lot of experience with class actions. And I think if they thought there was a class action solution that made sense, they would do it. Part of the difficulty may be the way some of these, because we're not talking about mass tort Chapter 11s for individuals. If you look at the Boy Scouts, for instance, or the diocese, it tends to be an individual tortfeasor and allegations of responsibility both against an individual, you know, that's not a party to the bankruptcy, not a debtor,
yeah.
But then also a sort of a secondary is probably the wrong word, but organizational liability for the acts of some individual. And it's a little hard for me to imagine trying to package the class action to get that commonality,
yeah, right.
In a way that would make it as universal as the bankruptcy.
Yeah. Well, you know, come to think of it, what about the point of view of the plaintiff's bar? I guess if you're a plaintiff's lawyer and you succeeded in getting to a jury and you got a judgment for $2 billion, you love the tort system. But does the plaintiff's bar overall find value in the bankruptcy system as opposed to the tort system?
You know, it's interesting. I tend to represent debtors, but I think, as I said, you know, that's a sophisticated group of people. They've been through a number of bankruptcy processes now. I think there are some advantages to them. Number one, they don't have to expend extraordinary resources on each individual case. It is an efficient way to put a bunch of cases together, to have a negotiation on gross numbers. Some of these firms, you know, will represent thousands of plaintiffs, and they get to talk to the insurers who are going to fund liability in the tort system as part of a mediation process. Most of these, as we talked about on the panel, are virtually all of them are resolved through mediation. But it gives an opportunity to talk about the group of cases, the various insurers who are going to fund it in a comprehensive way, and albeit these are 2 to 3 year cases typically, a quicker way for many than to sort of have serial trials throughout the tort system all over the country. It is.
Well, you couldn't do it. I mean, you've got
staggering.
10,000, much less 80,000 plaintiffs. Tort system is simply incapable of it.
Ill-equipped.
Well, you know, all of this is sounding to me like bankruptcy is the least bad alternative for dealing with torts that we now recognize are horrendous.
It's certainly I don't think it was imagined to be that, you know, when it was written into the Constitution, but it's certainly seeming to be an evolving trend, and I think it will continue as, you know, as folks find ways to find organizational liability for individual injuries.
Well, you know, I can see why the plaintiff's bar likes it, because I guess they get their same cut of the recovery for each plaintiff, even if it's in bankruptcy. But what about the individual plaintiffs? What criticism, if any, do they have of the bankruptcy system? Or are they simply just happy to get it over with and get something?
I think there's a spectrum there.
Tell me about that.
And I don't tend to represent the plaintiffs as we discussed, but it's been described to me by somebody who does represent a lot of plaintiffs that, you know, they think about 3 things kind of right out of the box. Number one, I want somebody to apologize for what was done to me. I want somebody to be sorry for it. Number two, you know, I want 2 or 3. I want somebody to be accountable for it. You know, they want to see result of their action. And there's a range of other emotions. Number 3 might be get my day in court. It might be express the fact that it's not my fault. It might be finding ways to ensure that it doesn't happen to other people. And so a lot of the things that that are important to the plaintiffs from an emotional well-being, forget the monetary damages, which are obviously significant, but finding ways for them, if they want to have their story told, to be heard. There's sort of a cathartic effect to doing that you get a little more, interestingly, in the tort system, if you go to trial than you might in a bankruptcy system where there's a settlement. But ultimately, in many of these mediated resolutions, you find non-monetary measures that emerge from that might create a systemic opportunity for victims to be heard, whether it's in a meeting with the leader of an organization that was the debtor, whether it's public meetings. Sometimes there's archival remedies where documents are being, you know, collected and made available to the public, to scholars, to help sort of perpetuate the memory, to, you know, to let people be heard and for folks to understand what happened.
Yeah, right.
I guess the other thing that would go into that as well is, particularly in the sex abuse cases, child protection measures are mandated. Sometimes they'll create monitors to make sure that organizations are doing the adequate reporting or creating further and better systems to deal with them.
Well, you know, just a minute ago, you used the word mediator or mediation. And, you know, I can't think of a bankruptcy case in which there was any judgment of liability by the bankruptcy court. So how is it that you bring the parties together to come up with a deal?
Ultimately, there needs to be a liability determination, and the way that typically happens in these channeling, junction, trust sorts of cases is the mediation really typically tends to revolve around, okay, where are the pots of money that are going to fund the recoveries, and then what are the trust distribution protocols that are going to determine, you know, how a trustee divides those funds up among the various plaintiffs. And it depending on the tort, it can be individual factors about abuse that occurred to one person. In the opioid cases, it might be how a particular governmental entity had to spend money to deal with the problem, and those are typically worked out in mediation, but it's ultimately when the claim is presented to the trust that the trust may look at a matrix of factors and come up with some determination and pay the compensation. And I guess it's ultimately the payment of compensation that is the analog for a judgment of liability.
Well, you know, I gather that a bankruptcy judge, or even for that matter a district judge, if she or he were the one presiding over the bankruptcy case, would not feel comfortable in getting into mediation because you're getting into issues of liability. And so therefore, I gather that the judges themselves would be reluctant to get into that knotty issue of people basically admitting, yeah, we got to pay a few $1 billion. Could it be done without mediators, or is that an essential part of the process?
Look, I guess technically it's possible, but I think every one of these cases that I'm aware of that has resolved in a consensual plan has been done through mediation. And one of the panelists even remarked that you never even really get to brass tacks until you're on your second mediator. You know, because these cases raised a host of issues, whether it's insurance coverage issues, or whether it's the individual sort of eccentricities of state tort law. Sometimes you need mediators that are specialized in one area or the other. It's often done through teams of mediators,
really?
or successive mediations with different mediators with different expertise.
Oh, very, very interesting. That shows you how even bankruptcy law has had to evolve. And speaking of evolution of bankruptcy law to deal with this area, are there areas like how a plaintiff asserts a claim that where bankruptcy has evolved to deal with these unique situations?
It has, particularly in the abuse cases or cases where there is insurance coverage that needs to be made available somehow to pay for the claims. You know, what I think of as the typical bankruptcy case, you know, a proof of claim on a debt action. I sold you goods for X amount of dollars, you didn't pay me. That's a simple one-page form. And that suffices in most commercial cases. But when you're dealing with these tort claims and trying to convince an insurer that it's got liability for some bulk of these claims and ought to pay money, the insurers have specific contractual requirements before they will either concede liability or admit to liability. That's what they bargain for. So they ask for a lot more information on a proof of claim form in terms of very detailed information about times, dates, places, people, other entities, factors that might trigger a policy exclusion, for instance.
Well, all of that is certainly not on the official form for
it is not.
For proof of claim.
These proof of claim forms in these abuse cases have become quite lengthy and are heavily negotiated and ultimately sometimes heavily litigated.
Interesting.
But they're a much different animal than a simple one-page form that you see in the official form book.
Well, this has been a very enlightening discussion for me, because what you've helped me do is to focus on how our legal system is facing a new problem. And, you know, we don't have federal rules of civil procedure to deal specifically with stuff like this. And people like you and folks from the plaintiffs bar, my goodness, you have dreamed up something that didn't exist to meet a need that gravely needs to be met. It's really quite remarkable.
Well, you know, that's one of the beauties of our system of jurisprudence, is that there's no end to creative lawyers who come up with ways to bring issues up, and folks on the other side to figure out how to resolve them.
Well, you know, at the outset, you mentioned Manville. And that, for its time, was phenomenally creative. How you could save a company that was burdened with more debt than it could ever deal with and still remain in business because it was a good company. Well, Derek, that was really quite something. You have taught me a lot I never knew or even thought about in the area of mass torts. It really seems to me like bankruptcy is meeting a need that existed, but that the legal system really didn't have an answer for until people like you dreamed up areas that, you know, meet needs of due process and whatnot and get it done. So I thank you very much for what you have told us. Mass torts in Chapter 11 will be the fodder for upcoming ABI events and publications. To find out more, have a look at abi.org on the internet to see our latest updates on publications and events. Well, thanks for tuning in. In upcoming weeks in our Industry Viewpoints series, we will be talking with other experts in other areas that are affected by our turbulent economic times. Until then, be well, stay safe, and good day.